In 4 states, Texas, Pennsylvania, North Carolina, and South Carolina, an ordinary credit card company that sues you and wins usually cannot garnish your wages at all. Everywhere else, federal law caps how much they take. Almost nobody knows where those lines actually fall. There's a catch that costs people their protection. A wage exemption guards money as it leaves your employer. Once that paycheck lands in your bank account, it can look like an ordinary balance, and a creditor may levy it. The exemption does not always follow automatically. Start with the federal floor. The Consumer Credit Protection Act, 15 U.S. Code Section 1673, limits garnishment for ordinary debts. It's a ceiling on what any creditor can take nationwide, and states are free to protect more, but never less. The cap is the lesser of 2 numbers, 25% of your disposable earnings, or whatever exceeds 30 times the federal minimum wage. At $7.25 an hour, that's $217.50 protected weekly. So on $250 of disposable earnings, the smaller number, $32.50, is what goes. Disposable earnings means what's left after legally required deductions, taxes, Social Security, mandatory retirement, not after rent or car payments. 2 rules run at the same time, and the one that takes less always wins. That distinction surprises people. 4 states go much further. Texas, Pennsylvania, North Carolina, and South Carolina bar wage garnishment for most ordinary consumer debts, like credit cards and medical bills. A creditor there can still win a judgment. It just can't reach your paycheck the usual way. That is not a blanket shield. Even in those states, wages can still be garnished for child support, alimony, federal and state taxes, and defaulted federal student loans. And a judgment can still reach bank accounts and other property. Other states offer a head of household exemption. Florida's is the best known if you provide more than half the support for a dependent. Wages at or below $750 a week are fully exempt unless you signed a written waiver. Rules and amounts differ in every state that offers one. Different debts carry different caps, and mixing them up is the most common mistake. Consumer debts top out at 25%. Defaulted federal student loans are capped at 15% of disposable pay. Child support can reach 50 or 60%. The student loan limit comes from 20 U.S. Code Section 1095A. Child support limits sit in Section 1673B, 50% if you support another family, 60% if you don't, plus 5% when payments run over 12 weeks behind. Federal tax levies don't follow the 25% rule at all. Under 26 U.S. Code Section 6334, the IRS leaves you a set exempt amount based on your filing status and dependents, and can take everything above it. Now the trap. Wage exemptions apply to wages. Once your pay is deposited, many states treat it as just money in an account, and a bank levy can freeze it. Some states trace exempt wages into the account, others don't. Protection usually is not automatic. You have to claim it. After a levy, you receive a notice, and a short window opens to file a claim of exemption with the court. Deadlines are often measured in days, and they vary by state. If it happens, 3 things matter. Read the notice for the exact deadline. File the claim of exemption form with the court that issued the order. Bring proof, pay stubs and bank statements showing the money is exempt wages. One protection is automatic, under Treasury rules in 31 CFR. Part 212, banks must shield 2 months of directly deposited Social Security, VA, and similar federal benefits before freezing an account. Ordinary wages get no such automatic screen. Garnishment rules are federal at the floor and state law on top, so the answer really does depend on where you live and what the debt is. Look up your state's exemption statute and talk to a local legal aid office or attorney.